Well, I think we might start. My name's Jim Kennan. I'm the chairman of Greens List, and can I welcome you all here today. This is part of a series of briefings that Michael Green organises by way of CPD breakfast briefings, and this month he does them in a range of jurisdictions, but this month it's on personal injuries. We had stress claims last week, medical panels today. On the 24th of June, there's victims' rights to compensation outside common law claims, that is Section 85B of the Sentencing Act, and VOCAT claims. And then on the 1st of July, medical negligence, loss of chance or a new opportunity, following the High Court decision in Tabat and Gett. We have two speakers this morning. Maria Tsikaris will speak first, and then Arushan Pillay will. Maria Tsikaris was admitted into practice in 1990. She worked in insurance law, public liability and personal injuries litigation, and she worked with Dunhill, Madden Butler, and then with Deakins, and was a partner with these firms from 1998 until 2002. She has a wide-ranging practice. I can say this because she's two doors down from me on the 7th floor, so I see a lot of activity emanating from her room, including the Court of Appeal, Supreme and County Court and Magistrates Court. Immediately prior to coming to the bar, Maria also worked as a senior legal advisor to the medical panels, and that's of course a very relevant background also for what she's going to talk on today. So I'll ask Maria to talk to you first.
Yes, good morning and welcome. As Jim said, immediately coming to the bar, I did spend a bit of time at the medical panel, but my talk today was really focused about how we get to the panel and the provisions in the Accident Compensation Act that relate to making referrals to the panel. My focus this morning is primarily going to be in the work cover jurisdiction, because even though panels were, their function was extended in 2003 to include referrals under the Wrongs Act for occupiers' liability and medical negligence cases, those referrals seem to, well, they concentrate on the threshold question of impairment, and they're quite different to the court referrals that I tend to be involved with, and it's certainly a lot of the authorities focus on, particularly early, focus on the work cover jurisdiction. Masters and McCabery was decided in 1996, and by that stage I think panels had been around for probably 7 years. They were introduced in 1989 in a raft of amendments to the Act back then, but Masters and McCabery was a Court of Appeal examined the role of panels, and basically I think the court said that it really was the legislature's attempt to remove powers from the courts and divest them into the medical panel, and it came to the conclusion that a panel was a tribunal that gave decisions. They had critical powers to decide issues arising between workers and employers, and their role wasn't just a medical role or wasn't confined to looking at medical and the medicine, but it also included fact-finding functions. So they had a mixed function to determine issues of law and fact and to dispose of the issues that otherwise would have been disposed of by the courts. They were an alternative dispute resolution measure, and they're also a much cheaper method of disposing of disputes. I think in the initial stages certainly there was a reluctance by the courts to allow that divesting to take place, and certainly there were a number of cases where judges and magistrates were reluctant to make a referral, and in the earlier years there was a focus on the courts obtaining or hearing evidence, whether it be from workers as well as medical practitioners, before making the referral. in the case of H.I.H. Winterthur and Greaves, the magistrate actually went so far to hear evidence from the worker and also from all of the doctors, and when he got to the point where he'd heard all of the evidence, despite there being an application, and thought, well, even though one of the parties made an application to refer to the questions to the panel, he declined to do that and decided that the issues in dispute himself in favour of the worker. That decision was appealed, and on appeal it was overturned, and the reviewing court said it was wrong for the court to decide the issue. The courts must make the referral, and there are very limited circumstances where they're not to make that referral, and one of those is abuse of process. There have been some recent amendments to the Act which cover the situation, which will provide further scope for litigation, but presently for proceedings that were issued prior to the 5th of April of this year, the only real impediment to the matter going to the panel is whether or not there's an abuse of process. There was a trend prior to about 2003-2004 for the courts still to hear evidence prior to making a referral, and there are a number of authorities which said that the courts would be, that it was a permissible way to go, and that certainly by the court hearing evidence it would assist in the refinement of issues and also ensure that the probability of error occurring because certain facts are overlooked was reduced by the court's hearing evidence. But there's, in more recent times, there have been cases predominantly by Judge Coysh in the County Court which have really reversed that trend, and in recent times an application to refer a matter to the medical panel effectively meant once the questions were settled and all of the documentation prepared, evidence wasn't really called by the parties, and Coysh in Rose and Frankston City Council flatly refused to hear evidence and allow the worker to be examined and cross-examined prior to making a referral. There was a decision of Judge Punchon as a party in VWA where an employer wanted to test the credit of a worker because there were issues that they wanted to ventilate prior to a referral being made, and Judge Punchon refused to hear evidence and made the referral. That decision was challenged on appeal, but the Supreme Court, Mr Justice Mandy, held in that case that there was no error by Judge Punchon and he was entitled to make that referral without hearing evidence beforehand. It's not necessary for the medical panel to decide all of the issues in dispute between the parties, and in the case of Isuzu, General Motors and Jordan, the court looked at the basis upon which the court ought to consider what questions can go to the panel. As long as the questions are relevant to some of the issues and the opinion will be of assistance to the court in deciding the ultimate issue or resolving the ultimate dispute, then that is a matter that should go to the panel. Relevance is the touchstone, despite the mandatory requirement that the referral take place. There are instances, for instance, where decisions to terminate weekly payments are based on the basis of failure to comply with a return to work plan or to participate in occupational rehabilitation. A medical panel can determine and reach an opinion as to whether or not certain employment constituted suitable employment. It can't decide whether or not the conduct of a worker in complying or not was reasonable, but in looking at a rehabilitation plan or a job offer and determining whether or not that constituted suitable employment, that finding or opinion can assist the court ultimately in resolving the greater dispute. So a referral is still appropriate and can still take place. Referrals can also be made in respect of death claims, and Judge Koish in Kouzos in there thought that even though the medical panel couldn't decide whether or not a disease that was contracted by the deceased worker was due to the nature of employment, the panel could still direct its mind to whether or not employment was a significant contributing factor to the contraction of the alleged disease. So whilst the panel wasn't going to decide the ultimate issue, Koish permitted the referral because it was a relevant factor in the dispute. Kamina. Mr Justice Ashley provided some very helpful background and comments which looked at referrals beyond the case at hand, and he, in looking at the referral in that particular question, made some observations about what is a proper question in terms of Section B of the definition of medical question, namely whether employment was in fact or could possibly have been a significant contributing factor to an alleged injury. And he basically said that that was a question that could only be referred in the context of definitions B and C of the definition of injury, namely disease or recurrence, aggravation, acceleration or exacerbation of a pre-existing injury or disease. And he said that it was not appropriate to refer questions about whether employment was a significant contributing factor to alleged traumatic incidents as a backdoor way of asking the panel for an opinion as to whether such an incident may have happened at home or at work. The decision of Kamenar to some extent is relevant to the definition of injury prior to December 2003, but amendments to Section 82(1) still preserved the concept of significant contributing factor to apply to contractions of disease or a recurrence, aggravation, acceleration or exacerbation of a pre-existing injury or disease. Abuse of process. I said earlier that there's an obligation, a mandatory obligation on a court to make a referral to the medical panel, save as to whether there's an abusive process. I referred earlier to the decision of VWA and Judge Punshin, where Judge Punshin refused to hear evidence in relation to a worker's credit before making a referral. So that of itself does not constitute an abusive process. Magistrate Wright, in the matter of Sehan and South Pacific Tyres, he refused to make a referral because in that case there were issues of res judicata and issue estoppel, and in those circumstances he didn't accept that the referral should take place. In Beavis and St Vincent's Mercy Hospital, that was a case where a referral took place after all of the evidence had been presented and heard by the court. Counsel had made their closing submissions, and before the judge had handed down his decision, there was an application at the 11th hour for a referral to the medical panel. And that application was refused because it was just, well, the court in that situation said that there was an ulterior purpose for that referral to be made, and that was to prevent the court or to attempt to circumvent the court from making its decision. Timing's an important sort of issue in terms of when to make the referral. And there was a recent case of Skordos and Garnett that went to the Supreme Court, where Magistrate Garnett refused to make a referral that was sought on the day of the hearing. The matter had been the subject of directions hearing, and there'd been no notice of referral until the actual day of hearing, and that was refused because of the timing. The plaintiff wasn't ready to proceed on the day, so a short adjournment was granted by the court, and prior to the matter coming on for hearing on the adjourned date, a further adjournment was sought by the plaintiff because of witness unavailability. There are a number of further directions hearings, and then the matter was ultimately listed for hearing about 3 months after that first aborted hearing and failed application to make a referral to the medical panel. And when the matter ultimately did come on for hearing, a further application was made for a referral to the medical panel, and in effect Magistrate Garnett was asked to reconsider his original decision to refuse the referral. Magistrate Garnett refused to reconsider his decision, and also observed that the plaintiff hadn't availed itself of the opportunity of reviewing the original refusal and going to the Supreme Court. That was appealed. That second refusal to make the referral was appealed, and it was unsuccessful. And the court accepted and said that there was no error occasioned by Magistrate Garnett's ruling that a referral at that stage constituted an abusive process. That's probably, in that case, there was argument in the Supreme Court that it was an approach that was adopted by Magistrate Garnett in considering those applications for referrals. The court rejected that, but it's certainly something to bear in mind, because the different magistrates take different approaches, but certainly Magistrate Garnett is one that does put the parties under the blowtorch when there is a last-minute referral, and he's more than likely to find that there is an abusive process where there have been a number of opportunities throughout the conduct of the litigation to make the referral, and that hasn't taken place. And there are a number of reported decisions of his in relation to this abusive process. Magistrate Wright also has been prepared to decide that there's been an abusive process in at least one case that I know of, where there was a request to make a referral at the 11th hour. I think practitioners need to be mindful that these days at directions hearings or mentions, the parties are asked whether or not any of the parties intend to make a referral to the medical panel. So any last-minute change in instructions or change in position, I think, will need to be justified, because there is certainly authority for the proposition that a last-minute referral will constitute an abusive process. There have been some changes in terms of the timing in the recent amendments. I'll address those later. Procedural issues. Issues such as under Section 102 and 103 about notice of injury and not lodging the claim as soon as as practicable after the injury became known. In those sorts of cases, certainly Magistrate Wright thinks that Benedos is the way to go, and Benedos was a case where Judge Gordon Lewis refused to refer medical questions to a panel as such time as issues relating to whether or not Section 103 had been satisfied, had been complied with and determined. I think there was a number of cases that were decided last year by Magistrate Wright, Masawi and Sitot are two that come to mind, where applications have been made to make referrals to the medical panel, but there are issues about whether or not notice of injury had been given or the claim had been submitted appropriately, and those issues were ventilated before the referral could take place. Evidence was called, and I think Magistrate Wright's very careful to ensure that the evidence that is presented and called only relates to these jurisdictional issues and doesn't stray beyond that, and doesn't. It's not a backdoor way of a party to try and attack credit or look at other factors in dispute that don't fall within the jurisdictional issues. Amendments. Just when we're all really comfortable and cruising along and know what we're faced with in the scheme, we have a bit of a changing landscape, and there have been a number of amendments to medical questions and the functions of medical panels that were introduced in the most recent amending Act. New question or a changed definition of ABC, whether a worker has a current work capacity and is likely to continue indefinitely to be incapable of undertaking further or additional employment or or work that would increase the worker's current weekly earnings. That's really a question that relates to the application of 93CD and where a worker is seeking to continue to receive payments after the expiry of a second entitlement period on the basis that they've got a limited working capacity. Question AC has been amended to include a question in relation to personal and household and occupational rehabilitation services and whether or not such services are adequate, appropriate, or the frequency of such services. Up until these amendments, panels did occasionally, well, questions were formulated to ask the panel as to whether or not a personal, household or occupational rehabilitation service should be provided to the worker, but it was usually done on the basis that the parties consented that that was a relevant medical expense. And that was a way that the courts have sort of gotten around the more restricted definition of that question. That's now been extended so that where consent of the parties isn't required and any party can make a referral to the panel, subject of course to complying with the other provisions. The section, I beg your pardon, definition F has also been changed, but it's really only added the word or, so it doesn't affect that. New questions have been added. Definition ABAA, nothing like a straightforward numbering system. A new question can be asked as to whether a worker on a particular date or during a particular period had no current work capacity, and if not, what employment would or would not constitute suitable employment on that date or during that period. So the question now can direct a panel to making a finding as at a particular date, and that's important because the definition of the question as it presently stands, or it stood, confined the panel to looking at the time that they conducted the examination, and so it's now been expanded to allow such an examination on a particular date or during a particular period, and that avoids the outcomes that were addressed by the courts in the decisions of Kumar and QBE and Angevin and Fry, where a panel, for instance, in Kumar decided that there was a finding of current work capacity in 2005, but the termination had taken place in 2001, and whether or not there was a real vacuum in that case about what would happen for that 4-year period of arrears, and ultimately in that case it was a matter for the court to determine whether or not the plaintiff could establish that there was no current work capacity at the time of the decision, as compared with a current work capacity at the time that the medical panel decided the questions. This question will probably, well, hopefully we'll avoid that situation, so there's no need to revert back to a hearing of issues in dispute. questions CA and FA are really similar to questions C and F, except though that the question's framed in the present tense rather than in the past tense. So the court is directing their mind as to the question of the extent of the physical or mental condition which results from, rather than when it resulted from or was materially contributed by. And similarly, FA, whether the worker's incapacity for work results from, as opposed to whether it resulted from. Those provisions in relation to the changed and new medical questions apply to referrals on or after the 5th of April 2010. Section 45 has been amended to apply to proceedings commenced on or after the 5th of April 2010. And now, in addition to the proviso that a referral not be an abusive process, the amended provision provides that a medical question, a court must not refer a medical question if that there are critical factual issues in dispute which are more appropriately determined by the court. And that takes us back to a situation where there's a legislative embodiment of the position that probably was adopted by the courts pre-Rose and Frankston City Council that Coysh adopted in 2003. I wait to see how these amendments will be played out and to what extent there'll be disputes fought out in the courts as to factual issues. I think Magistrate Wright's also made that observation that he'll be interested to see how the parties and how practitioners in the jurisdiction adopt and embrace these provisions. Also provisions that relate to the timing. Section 45(1)(b) has been inserted to say that an application for a request to make a referral must be not less than 14 days prior to the date fixed for hearing or such other date listed by the court. Section 65 has been amended to allow a medical panel essentially to refuse to give an opinion on referral by a conciliation officer where the question substantially revolves around the resolution of factual issues. So that's a sort of a corollary provision to Section 45 where there are referrals made by a conciliation officer and the panel considers that there are factual issues that ought to be agitated. Also in relation to Section 65, the medical panel can request information from a personal body if it believes that it requires that information to address the medical questions that have been referred to it. And again, that provision refers to referrals after after 5th of April 2010. I think that was all that I was seeking to address you on this morning.